You probably committed a crime today, not a serious one. Maybe you drove slightly over the speed limit, jaywalked, or downloaded something without paying for it. You didn't think of yourself as a criminal. But here is what's strange. The very concept of a crime, a violation of a rule serious enough to require punishment from the group, didn't always exist. There was a time, deep in human prehistory, when crime as a category hadn't been invented yet. And the moment it was, it tells you more about the nature of human society than almost anything else in the archaeological record. So what was the first crime ever? The honest answer is that we don't know precisely. Crime requires rules, and rules require a society complex enough to need them. But archaeology, anthropology, and the study of the earliest written legal codes have given us a remarkable picture of what the very first prohibited behaviors probably looked like, who decided they were wrong, and what happened to the people who violated them. To start, you have to go back to a world before law, not a chaotic world. Your ancestors were highly social and cooperative long before anyone wrote anything down. But the rules governing their behavior were not codified. They were social. The enforcement mechanism wasn't a court or a prison. It was the group itself. Anthropologist Christopher Boehm at the University of Southern California has spent decades studying what he calls reverse dominance hierarchies in hunter-gatherer societies. The consistent tendency of small ancestral groups to suppress individuals who tried to accumulate too much power, take more than their share, or bully others into submission. Boehm's research across hundreds of documented forager societies found a striking pattern. The behaviors most reliably and most harshly punished in ancestral groups were not murder or theft in the modern legal sense. They were behaviors that threatened the group's equality and cohesion: hoarding, bullying, refusing to share, claiming more meat than your labor justified. In other words, the earliest crimes were not crimes against individuals. They were crimes against the group. This makes evolutionary sense. Small bands of 20 to 50 people living in harsh environments depended on cooperation for survival. An individual who defected from cooperation, who took more than they gave, who dominated rather than contributed, was not just annoying. They were an existential threat. Groups with effective mechanisms for suppressing these behaviors outsurvived groups without them. The impulse to identify, condemn, and punish social defectors is, in this sense, one of the oldest social technologies the human species ever produced. But when did crime become crime in the formal sense, with written rules, designated punishments, and an authority empowered to enforce them? The answer comes from Mesopotamia, in what is now southern Iraq, in the 3rd millennium BCE. The earliest surviving legal codes in human history come from this region. The Code of Ur-Nammu, dating to approximately 2100 BCE and considered the oldest surviving written law code, contains specific penalties for specific offenses. Remarkably, many of these earliest written laws do not prescribe the death penalty for violent crimes. They prescribe fines. A man who broke another man's bone owed him a specific amount of silver. A man who cut off another man's foot owed him a fixed payment. The earliest formal legal system we have evidence of was built not primarily around punishment, but around compensation. This tells you something profound about what the first formal crimes actually were: violations of a social contract based on exchange. You harmed someone, you owe them. The debt must be repaid to restore balance. Murder appears in early legal codes, but what's fascinating is that even murder was often treated as a private matter between families rather than an offense against the state. The concept of crime as a violation against society itself, rather than a specific injured party, developed gradually and much later. Theft is another candidate for an early formal crime. Archaeologist Guillermo Alguez at UC San Diego has studied the economic organization of early Mesopotamian cities and found that the emergence of stored surplus, grain, livestock, and valuables held in temples and warehouses created the conditions in which theft became a category requiring formal prohibition. Before surplus, there was nothing to steal in a meaningful sense. Hunter-gatherers carried what they needed and shared within the group. The moment humans began accumulating stored wealth, they created both the motivation for theft and the social necessity of prohibiting it. Fraud and false weights appear in early Mesopotamian records as well. Merchants who used inaccurate scales to cheat customers are explicitly condemned in texts from the 3rd millennium BCE. The world's first white-collar crime may be as old as the world's first commerce. But perhaps the most revealing early crime is one that modern people rarely think of as criminal at all: speaking falsely about another person. Defamation, slander, and false accusation appear in early legal codes with remarkable specificity. The Code of Hammurabi, dating to approximately 1754 BCE and one of the most complete surviving ancient law codes, devotes significant attention to false testimony. A person who falsely accused another of a capital crime and could not prove it faced the same death penalty the accused would have faced. False accusation was treated with the same severity as the crime itself. Why? Because in a world where reputation was one of the most important resources a person possessed, and where community trust was the foundation of every economic and social relationship, destroying someone's reputation through lies was genuinely catastrophic. It could end a family's ability to trade, marry, or participate in community life. In the ancient world, your reputation was not just socially important, it was a survival resource. Researcher Peter Stein, who spent decades studying the development of Roman law and its ancient antecedents, argued that the entire trajectory of early legal development can be understood as an attempt to protect the conditions that make cooperation possible: accurate information, reliable exchange, personal safety, and trust. The first crimes, in both the informal ancestral sense and the formal written legal sense, were violations of those conditions. What does this mean for how you understand the concept of crime today? It means that crime, at its deepest evolutionary root, is not primarily about bad people doing bad things. It is about behaviors that threaten the conditions under which groups can function. Every society draws that line differently, in different places, for different reasons, shaped by its particular history, economy, and values. But the underlying logic is ancient. Some behaviors make cooperation possible. Some behaviors make it impossible. The first formal crime was simply the first moment a society decided that a particular behavior was so threatening to cooperation that it required not just social disapproval, but an official response. You are still living inside that logic today. Every law on the books, every fine and sentence and court proceeding is a descendant of a decision made in some early human group. This behavior costs us too much. This cannot be allowed. This must be addressed. The first criminal probably wasn't a murderer or a thief in any dramatic sense. They were most likely someone who took more than their share of a communal meal, refused to participate in shared labor, or claimed status they hadn't earned. They were punished not by a judge, but by the group, not in a courthouse, but around a fire. And the punishment wasn't imprisonment, it was exclusion. In a world where exclusion meant death, that was enough.